Live.
All right, welcome to the House Judiciary Committee this Thursday morning, April 17th, and we're taking up S87. And we're going to start with the Defender General's office. And Rebecca, if you could join us. And this is on, we're looking specifically at draft number 1.1. Is that still, it's an amendment. There's other language that we've already heard from the Defender General's office, and I didn't understand that there was huge concern on the other language. This is the language that there are, from what I understand, some concerns. So.
Okay, thank you. I'm Rebecca Turner from the Appellate Division of the Office of the Defender General. And yes, in fact, I did come in here. I forget when I came in last week's meeting, but I actually did raise some concerns about that first part. So I don't want to have any confusion as to the record.
Oh, okay, thank you.
There was, and I understand that the proposal here is to make this a quicker process. And I understand that from the waiver of extradition process, but my concern before was that this actually slows it down in terms of keeping someone here longer. So the current max time is 90 days. And now the proposal is extending that to 120 days detention before they're sent out. And so the questions I had, and perhaps it gives me a sense of opportunity to clarify. What is the cost by adding 30 more days in detention that Vermont is bearing? 30 more days of detention, the cost per day of bed space, who is paying for this, right? As well as the cost to someone who is being detained, because we're very limited protection because it's in the extradition process, right? There's the writ of habeas corpus available. There's the set statutory schemes for going before judiciary to get the preliminary doc set. But this is an environment where the 90 days was deemed a reasonable amount of time under the uniform code to allow the demanding state to get the necessary documents to the governor. And as I understood from the Attorney General's office, witness testimony, Sophie Stratton, it wasn't our side that needed the extra time. They were doing actually, it sounded like a very diligent job, turning a request around 3 days, is what I heard. But it was on the demanding state side that they needed the extra time. So questions for me is why are we giving the demanding state more time when it's their person and their priority to come get it? Is this a change that's happening elsewhere because this is a uniform code? So are other states also finding the 90 days limited, or are they also extending? And I understood again from witness testimony that this is not a uniform change that's happening. This is an outlier. So again, we're doing this as an accommodation for demanding states and at cost to Vermont, right? 30 more days of incarceration, the cost of incarceration, before even the demanding state then comes. So those were really huge concerns. The other part of it that we didn't get a chance to talk about, but I hope the committee looks at this. This is 2C. So I'm looking at as passed by the Senate. As passed by the Senate, page 4, line 6 through 8. And so this is getting into this section on waiver and allowing this expedited process in the specific context where someone has previously signed a waiver of extradition in the demanding state. And in here on page 4, not only is this entire section new, and so I'm going to talk about that in more detail because that's what I understand 1.1 goes into more detail in terms of the process. But what you don't talk about in D1, what I want to make sure gets addressed, and I didn't address it, I believe, in my last time here on that. Page 4, line 6 through 8, provides this third part. And the third part allows for, by default, as I'm understanding this section correctly, it allows for a person to remain in Vermont by default, unless the prosecutor agrees in the interest of justice, to make sure that all open prosecutions in Vermont are complete. And I just want to make sure that's what that intent is. My understanding is that's what it does. Now that's a substantial change. There's already a statute that allows the governor to make a decision to hold a person here in Vermont. Assuming the demanding state has sent all the materials and there's a governor's warrant issued to extradite someone back, the statute, and it's 4959, Section 4959 already authorizes a governor to hold a person here until the completion of a Vermont prosecution.
What's that citation?
4959.
It's 13.
13, yep, in the extradition chapter. And so what I read, this language is changing. A, it's changing this from just the governor's policy to all state attorneys. It also changes as a presumptive keeping all prosecutions here. For the person here until all prosecutions are complete. And remember that we're in this extradition scheme, so the normal constitutional protections like bail don't apply. Right to bail doesn't apply. So you could have someone here with a pending misdemeanor, PCRs, where they're otherwise bailable, a felony otherwise bailable. But they're held on this extradition. And now by default, they can be held without bail pre-trial on an extradition custody status, even though they would be bailable if they didn't have this extradition proceeding over them, until the prosecution finishes their misdemeanor or felony prosecutions. And so the huge concern from defenders is that you give the state's attorneys this kind of power. Now they've got the thumb on the scale to pressure someone who's been sitting in jail on a hold without no protections from pretrial release bill statute, but under extradition, to plead quickly to anything just to get out of detention, right? And so defenders have really raised concerns about this, flipping the plea bargaining power imbalance and really distorting and using extradition as a way to just tighten the screws on someone to be held pretrial. So
explain the bailable part again.
Right. So someone could have a pending Vermont felony or misdemeanor, otherwise eligible for bail.
Mm-hmm.
They go through that. They get bail issued. Right when they're about to post, an extradition request comes in. And now the person is in extradition processing is being arraigned before the judge. And there's, let's say, a governor's form issues properly, and that's recognized, so they don't contest it, or they do, and the judge reviews it, and the materials are valid. So it's a valid governor's warrant. Now you're sitting there until the demanding state comes and gets you, right? You're out of that 90-day window, 120, because the governor's warrant has issued. But now you also have this pending Vermont conviction that under this language, the governor, the prosecutors can hold.
So that's the language on page 4.
Right. And so instead of now being formally eligible for bail and release on that prosecution, they're going to be held without bail until that prosecution is over. So someone who's sitting in a hold without bail will be very incentivized to plead to anything just to get out of jail versus, have all of their constitutional rights available. Again, sorry. Yeah.
How is that not uncommon now?
Well, you don't have the hold without bail context in that case, right? So these lower level, high stakes cases, the difference is that pretrial release is not seen as punitive, right? In our constitutional scheme for bail, right? So it's used to ensure against federal prosecution. In this context with extradition, it now can be used as punitive because they're not being held without under the constitutional framework, but under extradition because there's a governor's warrant, right? So just think of how these two worlds interplay, and when they cross over each other, the extradition custody status changes significantly and distorts that power toward the prosecution to incentivize someone to plea out. Now, that's the incentives that are different because they don't exist without that pressure of a holder.
I understand that, but and very commonly we find an extraditable person because they get arrested for another offense here. And that's how we run across them. And we already know they're a flight risk. I mean, they've proven that because now they're here. And you can hold without bail.
And certainly those would be the arguments that could be made and the judge would consider in the bail context. But I'm giving a scenario which is not something that's far-fetched. Where a judge will hear those arguments from the prosecution, hear the other arguments, and make a decision to grant bail, to make someone release pretrial on conditions, right? And then this warrant comes down. And in that context, the court doesn't have the authority to release, right? So that's what I want you to understand. Right now, we have that. It's allowable, but it's the governor who makes that choice. Here, the language is significant in terms of how it's presuming the opposite and giving that in the hands of the state's attorneys.
So you could still let the bail situation play out. And set bail based upon the new charge, correct? And the two deciding people have to decide, well, you're not going to go back to where whoever's demanding you until we're done here.
So
Or you could let them return and deal with it later.
that's right. Under this language or under the current legal scheme, the governor doesn't have to ask for someone to be held and they just go back, right? Or in this proposal, actually the state's attorneys could determine in the interest of justice, because the default is to hold them here until the prosecution is over. But when I'm talking about when there is extradition, a governor's warrant issue, they're just waiting. And you've got someone who's here on a prosecution, on a case that's being prosecuted, that's bailable. And there was previously a court order granting bail. That no longer is a valid order because the extradition holds. So, okay.
That would be, well, yeah, I would, that would be a perfect time for them to sign a set of conditions for release, that they can be extradited back here if they don't. But the governor's warrant's going to be overriding anyway until that's resolved.
That's right. So I just wanted to point that out because that's a significant change that is proposed here that wasn't and hasn't been talked about as far as I so I want to make sure we would strongly object that and suggest deleting that entire section. And if you go forward with expanding another 30 days and the cost, I don't know who's bearing the cost. Was that 30 days? I'm going from 90 days to 120 days, right? Well, sorry.
Yeah, no, I just want
asking questions.
I want to clarify. I just want to make sure I understand. So 5043, which is on page 4, the person can be bailable. That's after the 90 days, right? That's so if you haven't figured this out in the 90 days or 120, if there's a 30-day extension, then the person is bailable. But it's specifically noting here that the judge should take into consideration. So, but it's the 90 to 120 days that you're talking about. That
is bailable. Sorry, right? There's a limited ability for a judge to grant bail on extradition. You're right. That is separate though from after the governor's warrant issues. Once the governor's warrant issues, right, and it's been upheld, waived, its challenges have been waived or it's been upheld by the judge. That's when someone can be held indefinitely until the demanding state comes. And we're in a different territory. So that's where the extradition bail doesn't apply.
Right. Okay. And your concern, just to make sure I understand, on that subdivision 3 on page 4, is that's replacing current authority to do this, which is in 4959.
It's not replacing, it's supplementing.
Well, supplementing.
And my point is if the concern is that you want to have the ability to keep someone here in Vermont to continue prosecution, of course, but that's already law. That's already law. It's under 4959. So you don't need this section. And in fact, what this section is doing is broadly expanding the ability to just default keep people here, and how that distorts, again, in the context of criminal prosecutions and the plea bargaining.
Right. No, I understand that part. I'm just trying to make sure I understand. So the individual has a misdemeanor, and then there's a warrant for extradition, and to get all that paperwork done, there's the 90 days, and at that point, they're holding the person until there's the governor's warrant from the other state that wants to get the person back, right? Or is it? I'm just trying to make sure I fully understand.
Right. Let me see if I can be clear. The bail permitted under the current extradition laws is pending the issuance of the governor's warrant.
And so the governor's warrant, just to clarify, because extradition's fairly new, certainly to me, the governor's warrant is from the other state, the demanding state. Is that right? Or is that when our governor says, yeah, we've signed off on it?
It's the latter. The demanding state makes a request, an
Yeah,
extradition
yeah.
request. And then the Attorney General's office handles the request, and then the government, and they can explain the process, but then our governor issues the governor's.
Okay, I just want to make
And
sure.
that is the point that is significant in terms of legal status, custodial status, and procedural process due. And that's the review, the available options is pre-governor's warrant.
Okay, and the 90 to 120 days is the time frame in which to get the governor's warrant, and the person can be held during that period of time. Once the governor's warrant is there, he can be held or she can be held until the other state comes and gets the person. Is that,
Once the governor's warrant issues, the person is held
yeah, until the other state.
until the other state comes. So one of the questions was, how long is it taking
the
for
other
the
state.
demanding state? That came up before. There were suggestions to talk to someone at DOC to find average times. Anecdotally from the field, we hear from our defenders, it's really different. New Hampshire is very quick, really, really super quick in Massachusetts to get here within same day.
Okay,
Other states can take.
and to nail down that, I think I understand this, but
Yeah.
so you have the governor's warrant now, and this person now can be, he or she is no longer bailable and can be held and the state's attorney can say, don't send them away because we want to try this misdemeanor first. And that means the person's not bailable because it's under the governor's warrant and also waiting for the case to be processed in Vermont.
And meanwhile, the demanding state's not coming. Yes, that's
The
right.
demanding state hasn't come to get them. And in fact,
And they
we
won't
may say
come.
to the demanding state, no, don't come yet. We're going to try this misdemeanor in the next 2 years.
That's right.
And the person's not bailable because the governor's warrant.
That's right.
All right.
That's right.
That helps so much. Yeah.
Yeah, no, sorry. It is very a confusing area of law.
There's been many times where we have not served the governor's warrant because we hold on to it while the person's been incarcerated.
And is the person,
Released, we serve the governor.
but is the person bailable at that time then? That's the concern, I think.
Yeah.
Angela.
I think that was very helpful. But just to make sure I'm understanding, so as soon as someone is on the extradition track and the governor's warrant is issued, that is, am I understanding correctly that process then takes precedent, like, or priority, like it sits on top of any other like state action that we might be seeking, state prosecution so the conditions of that hold will apply instead of the conditions of, the misdemeanor charge and the applicable bail options.
Yes, that is in terms of your question, custody. Yes, absolutely.
Okay.
It takes precedent unless and under current law, section 4959, the governor asks or has the person stay and to finish out the pending Vermont prosecution. But yes,
If the governor can say, we're going to have this person remain in Vermont while we finish out this prosecution, and is there an option there to say, and they won't be held during that time?
I don't think so. I think, and my understanding is that they have to be held once the governor's warrant is issued.
A little bit.
Yeah, hold without bail. And
That's the only option.
Yes.
Without bail.
So that's the only option, but I mean, is it possible to put into subdivision 3 that if the state's attorney exercises this decision, that the person can be bailable?
I don't know. That is again, these questions are highlighting how this is not an easy amendment to make without a lot of other implications. And I don't know about the ability with extradition law generally, whether or not we would have that authority as a state legislature, as a state legislature to do that. I just don't know the answer, frankly.
Well, that's a question.
It's very, and it's, I would like to say you could, but I don't actually think it might be enforceable, or it might be violating,
Very often, doesn't it, encourage the state of Vermont to come to a resolution on their person, the defendant here, charges in Vermont, potentially get sentenced, work a deal, do whatever, and run the time concurrently, even if they're transferred to the other state.
Mhm, mhm. There certainly could be, and again, those are whether or not the state will, the demanding state will recognize the time in here towards that sentence is completed. All, complicated questions and vice versa. But in terms of what we're talking about, in terms of understanding the custodial status, once that governor's warrant issues, they're just on a hold with that.
Ian,
So this is already an issue. So S 87 isn't creating this issue, right? Because if I'm reading 4959, so the governor could do this,
Yeah.
but what you're saying is that S 87 would allow a prosecutor to do it.
S87, the proposed language is that except as the state's attorney shall otherwise determine, it defaults to all open criminal charges in the state have been disposed of through trial. So it defaults to keeping someone here until all open charges are resolved through trial and sentencing,
Right.
unless the state's attorney exercises his or her discretion to determine in the interest of justice. So otherwise,
Yeah.
the 4959 language, and I was trying to pull it up, and you have it there.
Yeah.
Has it that I think the governor has to affirmatively make the request.
Yeah, the governor, in
Or-
his or her discretion,
Discretion.
can either surrender or demand that they hold them, and it's hold them until they have been tried, discharged, or convicted. So I guess so the issue that you're highlighting currently exists under law. I think is my
Well,
understanding.
yes,
But-
except
right.
that it's the governor
Yeah, it's
who is
about
making that.
who is making that decision. I'm trying to understand
Yes,
exactly.
yeah, no.
where-
So the point
what
is
we're making an issue of with A87 versus what.
right. The current law allows this to happen in terms of the ultimate concern, which is that we want someone to finish out the prosecution here in Vermont, right, before the demanding state gets the person. That is allowed, right? So that is allowed. And actually, it's just hearing you read the language from the statute, the governor has the inherent discretion to make that decision. There's no request that has to be granted. That was a misspeak if I said that. So that's already very powerful in terms of the exercise of discretion to hold and hold, but that's with the governor only. Here, the default is that they're going to be kept here no matter what. And now you're removing it from the governor's decision and discretion to all the state's attorneys, right? And they're the ones who are individually prosecuting this case. This is incredibly a shift in power balance in criminal cases in Vermont. And so again, where does this come from? This is a uniform code. Is this a movement that is happening in other states? Like sort of my overarching questions that I keep asking every time there's a proposed amendment. Where does this sit with others? But certainly here in Vermont, that has raised considerable concerns and should be deleted. All right, so then
we're fixed. If it's fixable.
I don't think it's fixable, but that's on the record, I think, clear, but because it's already established in the statutes with the governor allowing this. So if you give the prosecutors individually any more authority on this, you are truly distorting the plea bargaining context in these cases, using the hold without pretrial against them in terms of encouraging them to plead to anything just so they can get out of jail, right? Even if the prosecution's case is incredibly weak, even if the person is innocent, and as are a lot of people who end up pleading.
But they obviously have another step before getting out of jail that they realize that they have to accomplish, and that's dealing with the other state. They're gonna have to go back there and answer to the same thing. So, and I agree with what you're saying, but they've already demonstrated the ability to flee interstate to avoid prosecution. You can hold them without bail.
Yes. But let's say they want to get there much faster,
Well,
right?
then I want to
And
encourage them to deal with the Vermont thing as fast as possible.
to encourage them is to have the heavy scale of sitting in jail when they are presumably innocent, where the state has to prove its case beyond a reasonable doubt, and on and on and on, all the fundamental constitutional rights that attach to a criminal defendant to protect. Okay, that is where the concern of sort of this fundamental fairness of
And it should be getting credit towards that other prosecution in the other state. They should be. I mean, that would
That
be.
depends on the other state.
It depends on the other state. It's optional. They do that frequently.
So moving, unless there are other questions on that point, I'll move to the other section, which is the 1.1 draft.
Ready?
Again, I was hoping that the AG's office would come and testify ahead to explain where this is coming from. So I'm going to just take a guess at why 14 days, but I don't know where 14 days comes from. I don't know where this is in terms of other states establishing this. Is this coming from a model of other state legislatures that have adopted this language? Again, we're in a uniform code context. So why are we doing 14 days here? But in both substance and form, this section is concerning and is a lower standard than what is currently set. So I just want to make sure that's clear in both substance and form. So let's first look at what's required to allow for this summary proceedings, to bypass the governor's warrant process, to bypass review from the judiciary, to bypass right to counsel. All right, so three things. So all you have to have here is, it looks like, a written request from an arresting law enforcement officer of this state. A written request from a law enforcement officer from this state. And it's D1, and it lists three things that has to be provided in this statement. The three things that have to be provided are less than what have to be provided to the governor by a demanding state when they're making a request for extradition. That's significant. It's significant. You're already at a lower procedural due process level than is the standard for extradition, right? What has to be provided to our governor when the demanding state wants someone to be extradited back? Yeah.
But that's because of the waiver. Right, so it is lower, but it's because they've waived and they've made an agreement that they understand that, you know, if they are if there is going to be an extradition, they're waiving that extradition, right? I guess yeah.
Right. You're getting right to the heart of it, which is that does the fact that there was an authenticated waiver of extradition process executed in another state, does that allow for us to bypass proof that there is actually an information indictment filed, right? And alleging a criminal charge supported by probable cause, and all the things that underlie and protect the justification for issuing a governor's warrant in the first place. Remember, this is an absolute extraordinary exercise of authority to arrest someone, hold someone, and have someone transferred to another state. Now, there are valid reasons to do it, obviously, under the Constitution, but to justify it consistent with not just the extradition laws, but also consistent with the other constitutional provisions, specifically due process and Fourth Amendment. No one has talked about the Fourth Amendment in this context or due process, but it's consistent with that. Before you can seize someone, and this is a proposal to seize without a warrant. You don't have a governor's warrant, you don't have a judicial warrant. Seize without a warrant, arrest someone without a warrant. Don't go before a judge within a reasonable amount of time. Again, our current law, both in Rule 3 of the criminal rules and in extradition, whether there's a governor's warrant or no governor's warrant, is to bring someone within promptly, within as soon as may be, forthwith. This is the language in these statutes, and that's been interpreted to be 24 hours or 48 hours if it's the weekend.
So before you go on, just you said, wouldn't there be an arrest warrant in the other state or a bench warrant in the other state?
That's D1.
And then that's connected with the fact that there's this waiver. So I think there's an arrest warrant. It's just that not the governor's warrant. So could you give me your comments in two different contexts? What if the warrant and the waiver of extradition process was in association with a sentence, like probation or associated with parole, as opposed to pretrial? You mentioned not having, proof of indictment, et cetera. That seems to be the pretrial conditions of release situation, which in my view seems quite different than if it's not under probation or parole.
So, right, and again, we also haven't talked about the other overlapping uniform code of, is it interstate agreement of entertainers, which could achieve the same thing in that context, where someone's already been sentenced, and they could be transferred under that separate agreement, but under extradition, there is this set of proceedings that have to apply, right, for process. And so let me just try to, you brought up something that made me want to, this issue of presumed validity because there is an arrest warrant issued in the demanding state, right? That's the issue now too. But still, due process, Fourth Amendment demands require that a Vermont judge, not just that we presume that the arresting warrant is valid, right? It protects the person by requiring these proceedings in Vermont, that a Vermont judge check and make sure that these are actually valid documents. And here what we have written as a proposal is that this is bypassing and everyone who is deciding whether or not these documents are authenticated is within the executive, is the arresting officer, isn't a judicial, impartial judicial magistrate. That's the issue. And so that's where the implications of due process and Fourth Amendment come in. It falls below the requirements even to justify extradition because let me look at D1 again. It's a written statement alleging that the demanding state has issued an extraditable arrest warrant. It's an assertion, but I don't read here that actually even has to be provided, right? First there's that issue. I think that earlier in C, let me look at C. You can bypass the governor's warrant entirely and see where the person has signed a prior waiver, if all of the following apply, right? But how do we know they actually apply? We know because in proposal D, the arresting Vermont officer says so in a written document to a supervisor without there actually even being, I think, a requirement to produce this. I'm missing that piece. So that's a problem. I just picked up now, just reading this. It's just an assertion by the Vermont officer. And then we have no one who is a judge or independent reviewing that these materials are actually valid. We have also, what else was, so there's no requirement for showing an indictment or information. We don't have a requirement that there is an affidavit supporting probable cause. Again, these are requirements currently in place for a governor's warrant to issue. To me, it seems like if you're going to bypass the protections currently in place by having a person go before a judge, have counsel, that these standards should be on par with what is required for a governor's warrant. A waiver of extradition proof isn't enough, right? It certainly should be this is part of the proposal, that it should be justifying expedited processes, that this waiver exists, but so should the other materials. It shouldn't be a lower standard than what is required for a governor's warrant when you're bypassing the judiciary entirely and counsel and the governors.
So I think I said last week, I don't know. Currently, without a waiver being signed by the individual in the now demanding state, we would have to charge them with being a fugitive from justice in the state of Vermont in an effort to hold them until we get a governor's warrant, or they waive extradition, send them back if there isn't a habeas corpus. Now they have signed a waiver in another state saying, I will waive extradition preemptively in case I violate and be demanded back. We sort of if we don't honor that, we sort of set up the other system for failure, because we're not going to give them back until we go through our process here. They're going to have to wait longer. The upside is they're here and they're gone within 2 weeks or under up to 120 days instead of wait for a governor. Knocked myself out of what I was thinking.
It is the nature of extradition. It's very confusing.
Right, but so and when they come to Vermont, the standard, if they waived in another state should be somewhat lesser than charging them with. But I don't see any issue with, okay, I just picked up so-and-so, they have waived their right to, and they're willing to go back. I don't see a problem with bringing them before a judge for screening of this. Not an arrest necessarily, but to make sure the documents fit.
That would also be
It just seemed, well, now, and that makes a difference. It would depend on whether they're probationary or a parolee or they're pre-adjudication. If it's pre-adjudication, I could see it happening. If they're a parolee or probationer, they're sort of a corrections responsibility.
And I think though, in the context where I think if I understand you're right, because it is different in terms of that, but that's where from multiple ways to get someone back, the interstate, the interplay with the interstate agreement of detainers could come in on that ground and work a different way.
Can I ask a question about that? Isn't what the detainer, that particular law is when it's understood that somebody from another state is in Vermont. And we essentially are taking over supervision of that individual. And if they violate those conditions through that process, they get sent back to the sending state. So it's a little bit different than here, because this person may be maybe running to Vermont to get away, and there's not any kind of agreement that we're taking over supervision. So that seems to be fundamental.
They're definitely different. I didn't come in today with a full briefing background on the Detainer Act, which is separately confusing. But others here might have the answer to that in terms of my only point to this was to bringing it up here was that there's multiple ways to get someone who's sentenced already in the demanding state back to the demanding state. There's another way besides the extradition. That's all I wanted to say. In terms of the extradition process, I think you've got it. The concern really is, and it should be a huge concern, that this is a proposal bypassing the judiciary entirely to check. And that is what fundamental extradition requirements are. It is a limited role that the judiciary plays generally, but it's critical. These things, there are mistakes that happen. And I also don't see a way around due process and Fourth Amendment concerns by creating a legislative scheme that bypasses the judiciary. And I wanted to bring up, and again, I know that Josh O'Hara, my colleague, came in previously, maybe in the Senate side and brought up this case, but has Lovejoy, the decision Lovejoy, come up? That's a Vermont Supreme Court decision, and that considered a challenge for a necessary delay in the extradition process. It's another Justice Dooley decision. He seems to have written much of the extradition decisions. Aren't that many extradition decisions, but Justice. All right, In re Lovejoy, it is 150 VT 588 1988. And in here, there was a question and challenge as to the constitutionality, legitimacy of allowing ex parte deprivation of an individual's liberty without requiring proof of identity relating to the extradition process. Ultimately, the court held here there was no problems with the constitutional analysis because of our statutory scheme requiring an early opportunity to appear before a judicial officer, right? And so that, and in fact, let me bring up that statute. The requirement to go before a judiciary in the extradition process, right? If it's with a governor's warrant is issued, someone's been arrested with a governor's warrant, they're still entitled to go before the court forthwith, 24 hours, 48 hours, the next arraignment, and that's under 4950. Under 4954, that section deals with the situation of arrest without a warrant. But because the person is suspected of being a fugitive, right? So arrested without a warrant, without a governor's warrant. Again, 4954 under the extradition task statutes, the statutory scheme contemplates bringing a person who's been arrested without a warrant and detained, not released on citation, before a court as soon as may be. And then, of course, we have criminal rule procedure 3G, which is arrested without a warrant. So must bring the person before a judge without unnecessary delay. So without unnecessary delay, as soon as may be, forthwith, all of this, as my understanding, quick drop down the research, has been also language interpreted in federal courts, consistent with Fourth Amendment and due process considerations, 24 hours, 48 hours generally.
So wouldn't they, in our scenario, still have the right under 4950 to request the writ of habeas corpus, which that's my understanding that that's the form of that relief?
I think the writ of habeas corpus is the only form here, but what is not allowed is going before a judiciary just for arraignment. They're arrested without a warrant and allowed to be held for 14 days. And if the demanding state arrives before 14 days, just arrested, seized, and transported to another state without ever going before a Vermont judge. That is incredible, has incredible implications under the Fourth Amendment on lawful seizures and due process. And so what I have not heard anyone from the supporters of this addressing that. In Ray Lovejoy, Justice Dooley addressed those constitutional concerns implicitly, saying it's okay because that section provides for bringing someone forward to your.
What, I got away from it a little ways. What constitutes proof of identity in judiciary's eyes?
I don't have that. Is it what's identified here in the proposal D1? Photocopy of identification, fingerprints. I don't have that answer. But I would hope that would match. It's a good question to check to make sure whatever is matching now. The other lowered standard here by form, the current whatever materials have to be requested to the governor for a governor's warrant has to be done in writing. Here, they're allowing the written requirement to be bypassed, so it can be just done in electronic form. Again, this is supposed to be to speed things up, as I understand it. But when you speed this up, you're now bringing in considerable fairness, due process, and just due process concerns, procedural due process, substantive due process, mistakes being found. Just note that how this is changing significantly from the current law. Again, form and substance, significant changes. Now, there's a proposal for 14 days to allow someone to be held, right, until the demanding state comes. And this is without someone waiving their right. It just allows them to be held for 14 days, again, without going before a court. I'm not sure where that 14 days comes from. I don't know. I'm not aware of a case that is considered the Fourth Amendment in this context. If people are going to point to model language, I would want to know, has it been specifically considered scrutinized under these constitutional forms?
Is that whatever is accepted when they waive extradition? What is that number? 60?
I don't know. We can ask the Attorney General's office person who tells where 14 days comes from. So just the timing, I know that we're going to lose
Yes.
Todd at 10:30. We'll give you more opportunity, and from the looks of it, we have a little more reading and thinking to do when we'll probably come back to this again next week. But let's
Thank you.
Todd, thank you very much. A lot for us to think about and think with that, Rebecca. Thank you very much. And like I say, we'll give you or Josh more opportunity next week to weigh in on where we're heading with this. Todd.
Good morning. Todd Davis from the Attorney General's office. My apologies for being a little late this morning. But my 12-year-old did learn how to change a tire on a dirt road. There's an upside to everything.
You made him do it?
She did, yeah.
She did?
Most of it. It's tough to crack the nuts, right? She was happy to be late to school. So I want to just take us back for a minute to talk through how sort of where this amendment is going And the space, and Rebecca is absolutely right. This is a confusing area of law. So I kind of want to slow it down. I also will say we had some good testimony from DOC last week, which I think did clarify some pieces. And I'm not sure the Defender General's office had a chance to review last week's testimony, but I think it'll provide some answers to the questions that were asked. So when I walked in, and there may be other questions here that I missed, the discussion was around this possibility under C3 of a prosecutor holding someone without bail as a means of leveraging a charge, a misdemeanor, what have you. I want to be clear, though, that hold without exists if a governor's warrant issues. C3 is no governor's warrant is issuing. C3 is about what is required before someone can be extradited on a pre-signed waiver. It's not a governor's warrant issue. The whole point is to avoid having to go through that long drawn out process of a governor's warrant when someone has voluntarily and with due process in their own state signed off agreeing to be extradited. And the goal of this amendment is simply to move that process forward so someone goes back to their demanding state where they have signed this pre-signed waiver. So,
Right, yeah, so the person is bailable.
depends, right? If the demanding state crime is punishable up to life, then it's not, then they're going to be held without. Otherwise, they are absolutely bailable. So that scenario of, that is an opportunity for a prosecutor to say, actually, no, I want to prosecute the crime here in Vermont, and then the bail requirements in Vermont apply to that Vermont crime. Remember, this is not somebody getting swept up. This is somebody who has been picked up by a law enforcement officer. That law enforcement officer sees the flag when they run the person's record, sees that there's an outstanding warrant, sees that it's extraditable. Then they contact the demanding state to see, is it still a charge? Is it still extraditable and valid warrant? And does the demanding state still want to extradite the individual? And if those three things are met, and this, I'm going to transition to the next point I want to make. That's when the language that is supposed under 1.1, the D section, comes into play. So there's a little bit of conflict.
Yeah, those three things that they need to, it's that part of this law that you said the three conditions, they have to contact the other state, find it out.
That's procedural. That's procedural, but it'll come through in this D section. The D section is not about when someone gets extradited. The D section is the requirements of that law enforcement officer when they deliver that individual to a corrections facility.
Barbara, and then Ian. It's Barbara.
So I'm having a memory of you saying that it's only for felonies in other states, not misdemeanors, and I just wanted to, if I have a false memory or not.
I believe it is generally felonies. I have to go back and look at yes, it's only felonies because that's the constitutional. That's my recollection.
On hold without bail?
No, on the extradition. And I think I'd have to go back and look, but I think it is the sentence requirement signals a felony.
Felony in our state or theirs?
Theirs. Yeah, it's a good question. And then so can I hold on that one for a minute? Because I think that's an interesting point. So this D section, right, is the requirement on the law enforcement officer to demonstrate a kind of prima facie, this is why DOC should hold this individual. It is not what authorizes DOC to extradite the individual under this amendment. This is just saying the law enforcement officer has to basically fill out a form that says, this person has broken, I've got a demanding warrant here from another state. This is the state is going to use this extradition warrant and wants to follow through, and there's a pre-signed waiver. So that paperwork, that summary paperwork, is delivered to DOC to hold this individual. Then we go back to the process laid out in C. Then DOC has to seek the authorized language from the demanding state that identifies the individual, that identifies that the pre-signed waiver is accurate, and that the demanding state is going to then receive the person. Once that's done, that triggers the 14-day process. It's really not, I'm not quite right. Once the person's delivered to DOC, that begins the 14-day clock. If DOC takes too long in that process, the 14 days is still running, but that's what's supposed to motivate. On that point, the Defender General was just asking, where did the 14 days come from? The testimony you heard from DOC was it's a broad range of roughly half the states, or maybe it's 15 states, do this kind of pre-signed waiver or honor them. The 15 days or 14 days sits kind of at the shorter end of the cycle. Many rural counties, and again, it's important to remember, most of this work is done in other states. They don't have statewide correctional systems. So it's towns and counties who hold these individuals. They range up to 30 days holding someone. Our thought was to find something in the middle, especially when we're looking at most of the extraditions are to Massachusetts, New Hampshire, and as Rebecca said, those are pretty quick. What we don't want is to be holding someone indefinitely while we wait for another state to come get them.
For instance, I guess, for an example. Well, I'll ask you, what happens in Vermont when we arrest somebody on a warrant that's from?
You mean any warrant?
Yeah, I just arrest somebody down on Main Street on a warrant.
Well, I think it depends on the county and what the prosecutor wants to do, or depending on the crime itself, whoever the prosecutor is.
But generally, let's suppose it's felony.
Then they usually get delivered to the nearest correctional facility and lodged until,
During working hours or on the weekend and nights.
well, if they can get before a judge earlier, it'll be that. But generally speaking, they sit in a correctional facility until the next.
For what purpose? To decide if this is legit or not.
Yeah, before they get an opportunity to go before a judge.
If we get somebody on an out-of-state warrant, we're not going to provide that.
Well, they have already, so we are arresting them on the basis of the out-of-state warrant that they have then fled. So the crime in Vermont would be charged as a fugitive. But given the pre-signed waiver, we're essentially saying we're sending this person back. You know, and on that note, and I can't speak for the state's attorneys, I'll let Kim do that. But I think we would be comfortable, not just comfortable, we would agree if it was a pre-adjudication that some further judicial process could be warranted there. If it's post-adjudication, I think.
I'm for this, don't get me wrong.
Yeah, I understand that, but I think your point on it, though, was well taken, which is if somebody has absconded but hasn't actually been convicted in a sister jurisdiction, having a court look at the documents makes some sense.
Well, essentially you're arresting the person.
Okay.
You're letting corrections deal with that. They don't arrest people. In certain circumstances they do.
Okay.
I don't see why we couldn't put a very quick judiciary stop in the beginning of this, just like we would with the state warrant.
You know, I think the only reason there is twofold. One is judicial resources, and you know, the goal here is to streamline a process where an individual has already in their home jurisdiction, you know, essentially made a bargain with their justice system to say, I get out on parole. I agree that if I violate the terms of my parole, just like any other terms of parole, one of those terms is I will willingly go back to the home state if I abscond.
I think it also offers a protective factor that it gives us the opportunity to check further for something that may be pending here that hasn't surfaced yet, a warrant that has yet been issued or whatever, because it usually takes a day or two from.
If it's that quick.
Yes.
I mean, I think the other point, there are other economies here, and I really think it is important. And not all those economies adhere to the state, right? Some of them do adhere to the defendant. I don't want to pretend that someone from the prosecutor's office is, you know, the DGO does an excellent job of advocating for their clients. But I will say part of the goal here is also to ensure that an individual isn't sitting in state custody in some way, whether it's supervision or actual carceral custody, awaiting this multi-week process that begins in the demanding state, runs all the way up to that state's executive, comes across to the Attorney General's office, runs all the way up to our governor, who does move very quickly on these, and then the individual is released to the demanding state. This streamlines that process, and again, it is part of something they've already agreed to in the demanding state. Maybe it's not helpful, but I will just flag my understanding of detainers, right? It means we already hold you in custody. You already are serving a term of sentence. We're not holding you in advance of charging you. You're already here, you've already been charged, it's been adjudicated, and we are holding you. And another state says, we want to charge you for something else. Vermont, hold this person once they're released from you, or even during the term of their sentence, release them to us, and vice versa. So we can go through with the charges. So detainer's not on all fours with extradition in this case.
Ian and Tom,
Really appreciate the clarification, and I now understand when we're talking about there's actually a governor's warrant at work, there's not, and like what's that? So I think one thing I want to clarify is right now, in current law, the only way that Vermont can say, okay, you have a warrant for this other state that has a warrant for this person, you want him. No, we're going to prosecute here. The governor has the only power to do that currently.
That's an interesting question. I think they could be charged here. And I mean, that is what C3 would allow.
So that's, but right now, let's say they're charged here. So they're in Vermont, they're charged with crimes in Vermont. There's also a warrant for them outside of Vermont. We do the full process. The governor's warrant comes, they want the guy, and our governor says, actually, no, we're charging him here based on whatever that site was, 4959. So right now, that's the only way.
So with deference to Kim on this.
Yep.
The state's attorney plays a role in that governor's warrant process, right? So there is a check in that regard. But if, let's say, the Windham County state's attorney is going forward with a governor's warrant request because the individual is arrested there, and the Bennington County state's attorney has a charge, then I think it may, and again, I want to leave this to the state's attorney's office, who has far more expertise on this than I, that may run to the governor once that governor's warrant process has begun, because otherwise the state's attorney in the state, in the prosecutor where the individual was detained and then found to be subject to an extraditable warrant, they would have the ability to say, actually, we picked this person up for a violent felony, and then we saw the extradition warrant. We're going to move forward with charging this person for what they're charged for here before we even move on the governor's warrant.
That's something the state's attorney can do now.
I believe so. But again, I would want, because I don't think they're required to move forward.
That's, I guess,
otherwise.
I'm just trying to, yeah, okay. 'Cause what I'm just trying to understand is how much are we sort of expanding the power of entities in Vermont to basically say no to to warrants from other states, and if like at the moment it's just the governor who can do it, expanding it so that states attorneys, if there's a waiver, and I understand, but saying that a state's attorney on their own can basically have that same power.
Yeah.
I'm trying to understand whether that's what.
It's a very good question. The intent is not to expand that power. The intent is to maintain the discretion that the prosecutors currently hold, which I believe is at the point of determining, do I charge for the crime in Vermont, or do I move forward on the fugitive from justice and governor's warrant?
Oh, okay. I think I was operating under the understanding that they had to move forward with the warrant if there was one.
No, I don't believe they do.
Okay. Well, that's helpful.
In fact, the state prosecutor in this state and the other prosecutor will often contact each other and discuss a plan.
Okay.
Because comedy doesn't require,
Yeah,
it's not first come.
it's not, okay.
I think this is for DOC, but I'm just wondering if there's a reimbursement to the state when we're holding for somebody else.
I don't believe so, but that's a DOC question, a very fair DOC question. I don't believe so. There are other similar or parallel tracks. For instance, the interstate compact on offender supervision, that does have some cost sharing because, if I'm under supervision in Massachusetts, but I want to live in Vermont, my supervision is transferred. There is some cost sharing there. I believe here, right? Technically, the crime has been committed by crossing into Vermont, and we're just moving you back. I mean, there's some other crime or some other infraction that has led to a law enforcement officer discovering that an individual has absconded.
I've been involved in that on the other end, and the other states aren't generally charging us.
So that's a great question for DOC.
Other states are charging us, or they're not involved.
And I'm not sure even without a federal overlay, I'm not sure what, it would have to be an executive agreement.
so I'm hearing that you're going to be looking at the difference when the situation is that somebody is on parole or probation and is a fugitive as opposed to pretrial, and you're going to try to put in some check-in with the courts on the latter, on pre.
And again, I'll leave Kim to speak to that from her perspective, but from our perspective, we're comfortable with adding that in, especially just given the nature of that. The only other thing I wanted to add, and I believe we heard testimony on this, so I'm speaking from my recollection, not from my research. To answer Rep. Oliver's question, in Lovejoy, sufficient identification was demonstrated by a signature, which is not what we're talking about here. Talking more than that, and the concept of waiting for the paper files to get. We talked about this originally in some of the testimony, or maybe it was in the Senate, but the concept of the reason we wanted reliable electronic means in the bill, one, that's how most legal documents are transferred at this point. And the other reason is if we waited on the paper, then we're waiting for a prosecutor to go to the court to get the original documents, to go to the post office, to put them in the mail, to send them to BGS, to have it delivered to the DOC facility. And that just has somebody waiting in limbo for even longer. And so that reliable electronic means allows this process to move faster. And reliable electronic means is used elsewhere in statute.
Yeah, okay. Other questions for Todd at this point? So I suspect that you, Kim, whoever at the Defender General's office, I don't know, it's Josh or Rebecca and Michelle can.
Whoever draws insurance.
We'll can talk about that judicial check-in, and right now we're talking about for the pretrial. All right, let's hear from Kim if she wants to add anything to our discussion and our understanding. Hello, Kim.
Good morning. For the record, Kim McManus, Department of State's Attorneys and Sheriffs. I would love to say that in a few sentences, I could clear this all up and have an easy solution, but that's not true. But I do want to just back up a moment. The Defender General was asking, sort of where does this come from? What are the other states doing? When I had the opportunity to dive into a little research, and I cannot say that it was exhaustive research, but some research into better understanding the Uniform Criminal Extradition Act, what I did find is that it is not quite as uniform as the word uniform would imply. The act does provide for states what a process, the extradition process should be, and then states tailor that a bit. There's definitely room within that. So one thing that I noticed was in that tailoring, this subsection C that came over from the Senate, that was part of the governor's proposal to create this off-ramp for pre-signed waivers for those who are on probation, parole, or otherwise on a release from a demanding state. This language is in the Uniform Extradition Act. It is not in every state's statutes concerning extradition. Some have it, some don't. So this is a choice for the legislature of whether you would want to add this language to our extradition procedures. If you did choose to do that, the language that was presented last week for D, subsection D, is to provide additional process here in Vermont and some guardrails to this idea. So I just wanted to put that out, that this language in C was not pulled out of nowhere. It does exist in the act, but again, some states have it, some states do not. When you look at states that have the language, there's again another division. Some states, through their case law, have decided that no judicial review is necessary, that the judicial process, the due process that happened in the demanding state for the person to have had signed this pre-signed waiver is enough. And those states do not provide a moment before a judge before sending them back. Some states who have this language do provide a judicial review. So again, a choice for this legislature, whether or not you, one, would like to have this efficient off-ramp for those with a pre-signed waiver. And then if you do, whether or not there is a stop before a judge. And if there is a stop before a judge, the one thing that I would just say to the committee to consider is that if this pre-signed waiver is authenticated, that it is then that the language for the judiciary is that it is honored and the person is held and then returned. Otherwise, if we're going to have a judicial review and then provide discretion at that point, we may as well just do the regular extradition process, right? So that's just a few things for the committee to consider. I don't think I need to go through a lot more at this point. If the committee wants AGO's office, DGO, for us to talk more about whether we can come to some place in the middle. Though I will add to Attorney Delos's point, from the state's attorney's perspective, we do see, if we're looking at why someone has signed a pre-signed waiver of extradition, we absolutely can appreciate the difference between a post-adjudication pre-signed waiver and a pre-adjudication, whether someone's out on bail with a pre-signed waiver. So that's an easy line that we can make, that again, this efficiency for an off-ramp would be for post-conviction only pre-signed waivers. That is something we can fully support.
And I think the idea is to still have an expedited procedure for the pretrial, but with the court check-in. So.
And again, we would support that.
Angela.
I was wondering, Kim, if you could, I have two questions. One, if you could share an example of language, statutory language of state that you know of from your inexhaustive, but certainly acceptable amount of research that does lay out a judicial review process.
So what's interesting there, and again, not exhaustive, and I would say I'm happy to do more, but I don't know if happy is the right word, but I will do more if the committee would like. What was really interesting when I looked was that in statute, states that had this additional language did not have the language that we're suggesting is added on. It was just through case law, through litigation, that the states decided what that state believed was necessary. Again, I can look further, but that's what I was looking for, because to be perfectly honest, we love to copy and paste where we can. So I was looking for language from elsewhere and I could not find it. And that's when we tried our best to create some language that we thought for Vermont's purposes would give DOC the authority, make that clear, make it clear to law enforcement what they needed to do, but then also provide guardrails so that we did not have a detention for someone unnecessarily long while waiting for the demanding state.
Gotcha. Thank you for that. And then my second question, just about this page 4, lines 6 through 8. As you've heard, there's been some discussion about whether or not this expands state's attorneys' influence or discretion, and how it might prejudice the any negotiations for someone who's being held, or I just wanted to hear your thoughts on that. And I appreciate Todd's point that the intent is to maintain maintain the level of power and discretion that already exists for state's attorneys. So I wonder what you think about that.
Yes, the intent with that language, my understanding was not to in any way expand our power to go above and beyond what we are allowed to do in a traditional or regular extradition process. What I would say here, and I do appreciate the Defender General's office pointing this out, is that I think we could easily solve the potential problem here with some additional language, that if the state's attorney, in the interest of justice, wished to resolve the case in Vermont and not allow the immediate departure for the pre-signed waiver, that then, you know, no longer the immediate departure pre-signed waiver route is closed, and therefore the regular extradition process would need to start. So again, like if we're looking at this as an off-ramp, right, those three things listed, 1, 2, 3, need to be present. If the state's attorney says, oh no, actually I want to prosecute the DUI here before they go back to Virginia, then we wouldn't be able to just, we wouldn't want, our intent is not to then have this person held because they have a pre-signed waiver. We would then, and again, I think we could clarify this with some additional language. This person, basically, all the elements are not met here. If the state's attorney says, no, we'd like to continue our case here. So again, start the regular extradition process if that's what needs to happen. But again, we wouldn't be looking to hold a person just because they have a pre-signed waiver.
Okay, great. Yeah, that I would be curious to see that language change. Thank you.
You have a question?
Yeah, Kim, and I think it was answered, but just from your understanding, so under the current law, if there's a warrant from another state, the state is in, but the individual is also charged in Vermont and is being held, or they have bail or whatever on the charges in Vermont, the state's attorney can decide to just not act on the warrant from the other state and prosecute that individual in Vermont right now.
That's my understanding, yes.
Okay, great.
All right, so we're gonna have some more work on this, and depending on whether there's still big issues for the post adjudication, not having a court check-in, it may be helpful to further understand, not today, but sometime in the future, the interstate agreement on detainers and the interstate compact for the supervision of adult offenders to see where the similarities are. So we may want to do that as well, just to flag that. I've been trying to understand that, some information that Kim has sent me, and I'm still confused as can be, and don't exactly see how it relates to what we're doing. I mean, I do see it, but I don't see anywhere where individuals can be held without access to court process. But we'll leave that for another day. I thank you very much for that. We're going to just take 5 minutes real quick, because I know we have some witnesses here, but so that we're all able to fully pay attention, we need a 5-minute stretch.